Much. I appreciate the opportunity to come speak with you all today. My topic is what the U.S. Supreme Court did in 2014, there's actually a case that I'm going to talk about that hadn't happened yet, and on into 2015, and the impact of that on patent litigation. A couple qualifiers before I begin. The first is that, as was introduced, and I'm not going to talk about myself that much, but a couple things that might be important or relevant as you understand my perspective on this is I have a lot of experience, but the primary experience I have is on pharmaceutical patent litigation, U.S., and it's on Hatch-Waxman, and it's representing generic drug companies against branded pharma. And so as a result of that, because that's what I do all day, every day, my perspective on patents is in the defensive posture. And I will naturally have opinions about these cases and the perspective on litigation as we go forward with that. And my biases will come through, and you'll have to just bear with that. The other thing is I'm a patent litigator. I'm not a patent prosecutor, and so to the extent I could add value to cases that you've probably already aware of and have probably read yourselves, hopefully what I can do is give you a perspective from the trenches, from the actual litigation that occurs in the United States on these patent issues, because perhaps that's a unique perspective to all of you, and hopefully I can add some value to you in that respect. So I'm talking about the Supreme Court cases. This is our very grumpy bench of the Supreme Court justices. They were extraordinarily active in 2014 on patent cases. To give you an idea, they decided in the area of intellectual property as many as 8 or 9 cases, depending on how you count. And that's highly unusual. In fact, you can count on one hand the number of actual patent cases that they've handled or taken up in the last 20 years or more. So they were incredibly active. I think there's 2 reasons for that. One is that they traditionally take cases when there is a split in jurisdiction but in one part of the country to another. So they take cases that have been heard by the circuit courts, and you have regional courts that are then go up to the Supreme Court. One of the standards of them deciding a case, and this is deciding to take a case, is if there is a split in jurisdictions, so the Third Circuit or the Fourth Circuit disagree on an interpretation of law, that's a case that the Supreme Court very much would be interested in taking, no matter what the subject matter is, because they're able to resolve that. In patent field, intellectual property field, we have the Federal Circuit. And so there isn't a lack of uniformity at the appellate level in decisions. So it's very easy for them, and they like to find reasons not to take cases. It's very easy for them not to take it. But something changed, obviously, and so they started to take it here. And as we see with some of the cases, if we can get into the details, a lot of that has to do with their perhaps dislike of the direction that the Federal Circuit has taken with respect to their level of review of the trial court. And there's the case on one of them that's been decided regarding attorney's fees, and then there's the present case that we're waiting for regarding claim construction. The issue there was the amount of discretion that the Federal Circuit should have in reviewing the trial court, it's the district court's opinions. And so I think part of their motivation has been to perhaps correct the Federal Circuit in some respects, and that's important. The other motivator, which I think is extremely important as we look at some of the cases and we think about it, is their effort or attempt to address the non-practicing entities' plethora of cases that have exploded in the district court. We call them patent trolls if you don't represent them. And the Congress at times has attempted to address it. Most of the bills that have been passed in the patent field, which you guys probably know better than I do because they relate to prosecution, They have been weakened whenever they've tried to address the problem of patent troll litigation. The Supreme Court has issued a couple of opinions, and I think that some of the motivation was to do that. So, to the extent that I have time, I'm going to address a fair number of cases, but I'm going to do so quickly because my assumption is you guys probably have read them better than me. My focus is going to be on what do they mean, and what do they mean in terms of patent litigation and going forward. The first case I'm going to look at is not even a patent case, and it is a case that was decided at the beginning of the year involving the Daimler Corporation, and the case is called Daimler versus Bowman. I'm not going to go through the facts of that case except for the fact that the case involves when can a foreign corporation be hailed into court in a particular jurisdiction. And it deals with the general jurisdiction requirements of the United States when federal cases are being filed against foreign corporations. The reason why this is important is that it was decided that Daimler, despite an extensive sales history in California, was not subject to the general jurisdiction of the district courts in California. Despite the incredible amount of sales, they were found not to be at home in that jurisdiction. And the Supreme Court announced a test